Today, I want to take you through Article 10 of the Digital Bill of Rights. So Article 10 is the last article, and it's the right to future-proof freedom. So this is what we would class as a sunset clause when it comes to a bill. It means that anything that comes up in the future has to be covered under this bill, so that government can't just slip something in and expect you to accept it because, it's not covered in the bill. Well, this article makes sure that that doesn't happen. So point 1, no new technology may be used to diminish or bypass the rights established in this bill. So no new technology can circumvent the bill. And don't forget, this bill is at fundamental level. It's at constitutionally fundamental level. So it cannot be circumvented by government at all. Point 2, any attempt to introduce systems that centralize identity, restrict financial autonomy, or enable biometric surveillance must be subject to constitutional challenge. So that is anything new that could come under the digital ID banner, anything new that could come under the CBDC banner, and anything new that can come under the biometric surveillance banner has to be subject to constitutional challenge. So it is open to us as the people to challenge anything new that is brought forward by our government, and that is covered under Article 10. Point 3, any new digital technology used by government automatically expires after 2 years unless Parliament renews it following public consultation and impact assessment. A system that is rebranded, restructured, transferred to a new legal entity, or modified without substantive change to its core functionality shall be treated as a continuation of the original system and not as a new deployment. The 2-year clock shall not reset. 2 systems shall be treated as substantially similar if they collect equivalent categories of data, serve equivalent purposes, or affect the same population in equivalent ways, regardless of changes to their technical architecture, vendor, or legal basis. The Digital Rights Commissioner shall adjudicate disputes as to whether a system constitutes a continuation or a new deployment, with a presumption in favour of continuation. This prevents temporary systems from becoming permanent surveillance tools. So that's all really long-winded, but I'm going to break it down for you. So what does it all mean? So any new digital technology used by the government automatically expires after 2 years. So if they want to put some form of digital surveillance in place, and we've agreed to that surveillance for the use of catching criminals under the guise of Article 5. So, the biometric surveillance under Article 5 is that if a judicial warrant comes down, then yes, the police can use biometric surveillance because it's a critical part of policing. However, it cannot be blanket. It cannot be a blanket thing. But what this says is any new digital technology will expire after 2 years. And when it expires, government cannot just turn around and say, oh, well, no, we've tweaked it. We've changed it a little bit. We've altered it a little bit. No, that's a continuation, and it has to expire after 2 years. And if they want to bring a new technology, it has to be significantly different in its data collection, in its manner of holding data. It has to be considerably different to what was there before, because it would be classed as a continuation of the same system if it's not significantly different. So part 3 of Article 10 means that they cannot just creep in and keep surveilling you as an individual in the country just because they've got the equipment. So part 3 of Article 10 stops that. It has to be reviewed, and it has to be reviewed by the Digital Rights Commissioner, and that's someone that will be put in place to ensure that our rights remain intact and are not infringed upon. Two systems shall be treated as substantially similar if they collect equivalent categories of data. So that's the same thing. Like if there's a system in place and then they say, oh, well, no, we're bringing a new system in. But if it does exactly the same as the old system, that's not a new system. That's a continuation, and that's not allowed under Article 10. Okay. Point 4. These rights shall be interpreted broadly in favour of individual liberty. Any ambiguity shall be received against state power and in favour of personal autonomy. Courts must adopt a presumption of freedom when evaluating restrictions on these rights. So these are interpreted, these rights, the rights that you have are in your favour as an individual, as you retaining your right to individuality, to not be surveilled, to not have to come under the digital ID. This covers the CBDC, everything. It covers all of those areas where your individual rights are being infringed upon. So these rights are interpreted broadly in favour of individual liberty, your liberty as an individual to be able to live your life without being throttled by the system. Point 5. No emergency, crisis, national security incident, pandemic, or other exigency shall suspend, limit, or derogate from any right established by this bill. Basically, they can't turn around and say, oh, well, no, there's a crisis. No, we know that a lot of the crises in our country come from our government, are instigated by our government, and are not actually coming from the individuals that live in this country. So they can have their, oh no, it's an emergency, oh no, it's a crisis, oh no, we need to lock everybody in their houses because there's a deadly virus. No, we've been there, we've done that, and it will not limit our rights under this bill. So government can say what they like. This is fundamental at the constitutional level. They cannot take our rights away. Any legislation purporting to do so, including emergency powers legislation, public health legislation, counter-terrorism legislation, or any other primary or secondary legislation, shall be void to the extent of the conflict. No royal prerogative power, ministerial direction, or executive order may be used to achieve outcomes that would otherwise violate this bill. Now, that's really important at the moment because we've just read the news and the King has basically told us that he doesn't care what we think. We're going to have a digital ID. So no royal prerogative power can circumvent this digital Bill of Rights if we bring it in. So Article 10 protects against the King telling us that he doesn't care what we think. Okay. Parliamentary sovereignty is expressly and permanently subordinated to this bill in all matters failing within its scope. Courts must strike down any act of Parliament, statutory instrument, royal prerogative instrument, ministerial direction, or executive order that conflicts with any right established by this bill. This duty is mandatory, not discretionary. A court that finds a conflict has no power to read down, disapply selectively, or defer the remedy. The word must in this provision is used in its imperative, not permissive sense. In exercising this jurisdiction, courts shall apply the following standards. A. The standard of review is strict scrutiny. Any restriction must be shown by the state to be strictly necessary, proportionate, and subject to independent oversight. Courts shall not defer to executive assertions of necessity or national security without independent evidence. C. Where a violation is established, courts shall exercise the following remedies as appropriate. Issue immediate injunctions to halt unlawful systems. Order the permanent destruction of unlawfully collected data. Award damages without proof of individual harm in addition to any proven loss. And refer senior officials to the Director of Public Prosecutions for criminal prosecution. D. A citizen or civil liberties organisation may bring proceedings in any competent court without exhausting alternative remedies first. No court may stay proceedings on grounds of political sensitivity, separation of powers, or the complexity of the legislative programme. So, if Article 10 is violated in any way, shape, or form, those are the parts in place to ensure that government cannot overreach. So the standard of review is strict scrutiny. So if there is a restriction, like if government turn around and say, oh, well, no, we needed to do this because of particular issues within our country, then they have to be able to state exactly what those issues are. So that is complete transparency. Courts will not defer to executive assertions. So it will always come under scrutiny. It has to come under scrutiny. You cannot circumvent this bill without scrutiny. Where a violation is established, again, the courts will have to exercise the following remedies, it says. And we've gone through those. A citizen or civil liberties organisation may bring proceedings in any competent court without exhausting alternative remedies first. So as soon as a violation happens, if there is a violation, then we have the right to take that straight to the court and say, look, our civil liberties, our fundamental constitutional liberties are being affected, and this needs to be looked at. Okay, so what are the effects of Article 10? It locks the protections in place for future technologies and establishes automatic sunset clauses for government systems. It prevents circumvention through rebranding by defining substantially similar systems as continuations. It expressly bars suspension during emergencies, specifies judicial review standards and remedies, and it voids conflicting legislation. Subordinates parliamentary sovereignty and executive power to these rights in the digital domain. So they cannot wriggle their way through and say, oh no, there's an emergency, we cannot abide by the Digital Bill of Rights. This Digital Bill of Rights becomes foundational and fundamental as our constitutional rights to individuality and to digital freedoms that we have choice over. And that is Article 10.